Hello, everyone, and welcome to our webinar, Human Resources in Europe, Your Top Questions Answered. During this webinar, our experts will provide an overview of the keys to successful HR in Europe, followed by an extended period for Q&A. Many of you have provided questions during the registration process, but should any arise during the webinar, please feel free to enter them in chat. Now let's introduce our speakers. Our first speaker is Kim Sanderson. Kim has considerable experience supporting companies with their HR needs in Europe. In previous roles, she has worked as part of European and international HR teams, as well as in HR advisory functions. During her time working at Tesla, she helped rapidly expand their European operations. Her areas of expertise are EMEA employment law, acquired rights, and contract standardization. Joining Kim will be Suraj Sharma. Suraj is an experienced HR professional who specializes in employment contracts, benefits implementation, immigration, and mergers and acquisitions. He has spent several years assisting multinational companies in various cross-functional capacities and currently supports the HR needs of companies in over 40 countries worldwide. Now I'll pass the time over to Kim and Suraj to discuss our first topic, understanding your hiring options.
Thank you, Ryan, and welcome to the webinar. I know when clients are looking to expand across Europe, there are three main options and people consider all of them. So let's talk through them all. First one is looking at whether you can hire someone as an independent contractor. So what this essentially means is engaging somebody on an independent contractor or a consultancy agreement. A lot of clients look at doing it and there are a lot of pitfalls. So I suppose added bonus to this one is you are engaging directly with someone, you are not incurring any of the tax or social security liabilities. But that's also the biggest downside to them. So what tends to happen is a client will find a great person and say, hey, let's engage you on a consultancy basis. And that professional is working for you full time. They are on a company email and you let them have holiday, perhaps even some sick time if something happens. The moment you start doing that, you've already treated them like an employee. And all I would say is for anyone who is looking to engage an independent contractor is look at the rules of the country that you are working in. They can be very specific to that country as to whether this actually is a good option for you or not. The other part is, and in consultancy agreements, you do tend to see this a lot. You get the right of substitution, you have different invoicing terms. So you just need to be really aware when you're going into this, what the benefits are, which, to be fair, it always seems win-win. You pay someone the money and they're responsible for their tax and social security. But in practice, you may well just be essentially setting them up as a pseudo employee. And that means that should that person part ways with you or you part ways with them, they could launch a potential claim against you and said that, hey, they've been an employee all along. We've seen it happen. So just really ensure that you have guidance there. Want to add anything on that one, Suraj?
I think you covered it really well, Kim. The only thing I would add there, like Kim was mentioning about the risk, the main risk here, just kind of summarize that point, is treating the employee as an employee rather than as an independent contractor. So ultimately, if they are an independent contractor, they should be treating their work independently, meaning that they're not getting direction from the company as to when they do their work, how they do the work, and how they get paid for their work. They really should be getting an invoice being sent to you from their consulting company rather than from themselves as an individual. So like is mentioned on the slide as well, it is also a challenge to protect your IP because you don't have a relationship with these individuals as an employee. And then that PE risk from a corporate perspective is one of the larger risks that we see, because if you have an independent contractor who you've hired for 5+ years, you are now talking about a PE risk that goes back 5+ years. In addition to that, you're also going to have your employment risk that goes back 5+ years. So it's important to understand and be mindful that an independent contractor should not be a substitution for doing things the right way, the legally compliant way. If you are going to be looking at an independent contractor, you should be treating that as an actual independent contractor and not as a way to quickly hire an employee and treat them as an employee.
Thanks, Raj. The next option is engaging someone as an employee, so making them your direct hire. There are a couple of ways to do this. Some countries you can set up a payroll registration. Other countries that's not possible, and so it requires you to incorporate there. This means they're going to be exactly the same as your employees, I suppose in your domestic market, the best way to describe it. There are different ways to hire, whether that is putting someone on a full-time contract, part-time, or fixed term. I suppose the concept of regular or exempt doesn't really exist in Europe, but when you are looking to engage someone on a contract, the first thing I suppose to mention is that contract is going to be for that country. Europe isn't a homogenous mass, very similar to how the different states in the US have different laws. Every single country in Europe has different laws. So you are going to need a different contract for each country that you are looking at hiring somebody in. You can't just kind of go, oh yes, UK, great, we use that contract in Germany. The other consideration is a lot of the employment contracts have to be based in local language. So you can always use English so that you are able to understand it. And most employment contracts do have a fairly standard form of, you know, start date, what the job role is, etc. Main benefit to hiring people directly, they are your employees. You are able to direct their work, give them promotions, have commission, all of that good stuff. You're able to have benefit schemes if you've got the headcount. I suppose the biggest drawback to direct hires is it can be very expensive. The cost of hiring somebody on a contract means you are going to be paying employers tax, like corporate tax, VAT. It really depends on what you're doing in that country. So I suppose it's that total loading cost of what is it actually going to cost me to have this employee there. I say the other downside, of course, most people do prefer to be employees. It means they have a strong relationship with the company. They are buying into the company ethos. The biggest drawback compared, I suppose, to people saying as independent contractors is there is a lot of employment law in Europe. It's not the case of you can engage someone very quickly or part ways very quickly if it's not working out. So if you are expanding into a country, you do really need to understand the implications of how the employment law is set up there and what your obligations are as an employer, because it gets very complicated very quickly. Suraj?
I think that one thing you're going to hear us mention a lot in this webinar is really going to be with regards to doing the right research ahead of time. So Europe is a jurisdiction that's very hard to rush into things, and it's hard once you're there to correct maybe mistakes or things that you weren't aware of earlier retroactively. So it's very important to understand whichever country you're going into, you want to be aware ahead of time. And I understand it's going to be hard for a lot of businesses, but our best practice, our kind of pro tip is before you even start recruiting in that country, understanding what kind of contracts are you going to be offering? What kind of contracts can you offer? So full-time contracts versus part-time contracts, you'll have different requirements for those. Similarly, fixed-term contracts, you're going to have regulations around when you can and when you cannot use a fixed-term contract, or after how many fixed-term contract renewals does that contract then become an indefinite-term contract. So you're going to have those considerations you have to be cognizant of before you start to hire in those countries. Additionally, understanding what are your required policies to put in place. So in the UK, as an example, you're going to have a grievance policy you need to have in place for the employee to review when you give them their contract or upon request after they receive their contract. So understanding in those countries, where do you have required policies you have to put in place versus where can you, where do you not need to have a full employee handbook? So understanding those questions ahead of time is also important. So really what we're going to be kind of driving home throughout the course of this webinar and you'll hear us repeat this often, is be prepared, do the research ahead of time. It's going to make your life so much easier, because once inevitably something happens, an employee is going to, separate with the company, or you're going to rapidly expand into 8 or 9 countries in a matter of a couple of weeks. You want to be prepared so that you make less, you have less of a chance of making any mistakes that might cost you further down the line.
Absolutely. Third and final option is working alongside a PEO and EOR company. PEO tends to be the term that we use more now, to be honest. So the way that this works is you engage a company who hires essentially on your behalf. So it means that you aren't establishing a presence there, and it means that your professional is going to have a compliant employment contract, and they're going to be paying their tax and social security, and everything is then essentially governed on the agreements between you and the PEO. It works well in that employees, professionals are compliant. It means they have an employer, everything is directed through that PEO company. They're getting paid monthly. You're not having to think, gosh, what currency do we need to pay this person in? The downside, I suppose, of PEO is it's not a cheap option, because you are going to be paying your PEO company fees in order to process that payroll. But it's still considerably cheaper than getting caught for having a pseudo employee or setting up your own entity for just one person, because then you're into all sorts of corporate compliance, which is nowhere near my area of expertise. Other benefits of the PEO simply is just the ease of doing it and how quickly, because PEO companies such as us will have, excuse me, we have contracts, etc. there that we are able to populate and work alongside with you quite quickly to ensure that your professional gets what they're looking for on a salary basis. What would you like to add, Siraj, whilst I grab some water?
No worries, Kim. Yeah, I think that covers it perfectly. Really, the PEO is going to be your speed to hire, speed to market. That's going to be the option where setting up an entity may take you 4 to 6 weeks, and payroll registrations and getting your bank account set up and all of that. That's a lot of upfront expense and also a lot of upfront time. And typically, when you're looking to expand into a country for the first time, you're not going to be given 8+ weeks or whatever that might be to get up and running. So that PEO is a great option when you're exploring markets for the first time. You want to hire your first salesperson, or you want to hire your first business development person in the country to see if that market's going to work for you. The PEO is a great option. Typically, you're going to see it be an option until you reach a significant enough headcount to justify that setup cost. So what we see on our side a lot of times is clients will use a PEO for a year or two while they're exploring the market, and then in the background, in parallel, they're setting up their own entity once they realize that this is going to be an area where they want to establish their operations more formally. So you can really, it's going to give you the maximum amount of flexibility to explore a market, get in there quickly, understand if this is someplace that you want to be long term, and then you can make your next decisions about your direct hire process, or if you want to stay on the PEO as well. That's where you can make that next decision.
Now we're on to one of the fun ones. So employment law in Europe. A very brief overview, because we need a webinar for each country that will probably go 8 hours or so. The first main point to explain, and I know a lot of you who are listening to this may well know this anyway, but at-will employment doesn't exist in Europe. So the notion that you can hire someone and dismiss them, I suppose, quite quickly if it's not working out, isn't easy or practicable in all of Europe. Again, really varies on the country. But what this means is employees do have a lot more rights the moment they are engaged in an employment contract. So the employment contract is going to be a legally binding document, and because in a number of countries you have to file that with the authorities, whether that's with the Labour Administration, with Social Security before somebody starts. So you are recognised as that person's employer. Notice periods, I suppose, the main one that you would notice if you were from the US, that the kind of at will or 2 weeks notice, yeah, I suppose the notice periods in Europe can start at 0 in some countries through to up to 6 months very, very quickly, depending on the length of tenure. The checks that are done before somebody starts, so criminal checks have become a lot more standard across Europe, and some countries it would still be very much frowned upon if you asked to do a background check. An employee would be like, oh my gosh, why are you checking this out? Because it's just not seen to be the done thing. But with the expansion of US companies, it's certainly becoming a bit more prevalent. The one thing to really note on background checks is that the level of check that you can do is very much restricted depending on the type of country that you are in. So whilst criminal checks can be done in a number of countries, and immigration checks always have to be done to ensure that someone has the right to work, regardless of the status of the European Economic Area and people moving backwards and forwards. Whether you're able to check things like finances, or I suppose anything that is perceived to be a threat to somebody's privacy, doesn't really happen in Europe. So a criminal check is probably the extent that you can do. Most people would have their exam certificates to be able to produce to you if asked. The other parts that you see in Europe, and I know I've mentioned this with contracts before, so I suppose in this example we're just going to take it that somebody is an employee, so whether they're an employee on a PO or via your own entity, everything is written. There's no such thing as a verbal contract, because the moment you made a verbal contract you've pretty much written it anyway. The whole notion that it doesn't exist, as it were. Employment contracts generally have to be issued either on day 1, or in some cases up to 30 days absolute latest. Best practice would always be that before somebody starts they have a signed compliant employment contract. And I suppose one of the biggest contrasts to explain, and having done this for a number of years, what we call a contract in Europe is pretty much the US version of an offer letter, except it's a lot more legally binding. So we've seen clients who have issued US offer letters, and they've been issued from the US entity, they've confirmed the name, the job title. Now that's not a legally compliant contract in the country. It certainly wouldn't suffice on a go forward basis. But if you don't convert what you've issued as an offer letter into something legally binding, then that employee has recourse against you, because it's not being executed properly. So one thing I always say to clients is, have you issued them an offer letter? Even putting something on email and saying, hey, we're going to offer you this role on this amount of money, we'll follow it up with the contract. That can be legally binding in Europe. Suraj, what would you like to add on this one?
I think you covered everything really well, Kim. The only thing I would add on this one, like Kim was mentioning earlier, is with regards to the onboarding process. We'll get to the onboarding process in more detail in just a couple of minutes here. But really, the main consideration for employment law, I would say, in Europe is what is covered on the slide here, which is it's not similar to the US in most ways. And also within the EU, each country implements their employee protections differently. So you may notice some similarities between countries. In particular, all the countries are very employee-centric when it comes to protections for employment. So as an employer, your main responsibility is to follow the letter of the law as closely as physically possible, because your leash, so to speak, is very short in terms of ensuring that the employees are treated fairly under the various employment legislations in each country. So if you're going to be a multinational country in the EU in particular, you will have to be mindful of each individual country's laws. You won't be able to apply a generic law or generic policy in each country. And that I think is probably the biggest learning curve that we see for a lot of clients, which is you won't be able to do a global policy for various terms like vacation as an example, or sick leave or maternity leave, because each country is going to have their own minimum standards you have to follow. So I would keep that in mind as well. It kind of goes back to our general mantra of do the research before you go into these countries, because you want to ensure that you're setting yourself up to be successful and in compliance.
Thank you. Notice entitlements, I know I touched on briefly before. So one thing I suppose to make really clear in Europe is the idea of, and apologies because I've done HR for a long time and I always go to, I suppose, the more jaded version where most people are looking to hire. I'm already considering how difficult it could be on termination. So notice entitlements in Europe, very widely, it will genuinely be no notice at all, but I would say in Europe that would generally be in the probation period, and even then it's going to be on a very limited time, so it's going to be the first couple of months at most. Notice periods extend by tenure, and they also extend by collective agreement, which is mentioned below. Ending a contract in Europe, your notice entitlements are going to be very important. And all of these kind of link together, which is why they're on this slide. But a works council, you will, in some countries, have to establish once you've reached a certain headcount. Depends on the country, really does. But collective bargaining agreements, you could be tied into a collective bargaining agreement without necessarily knowing it even exists, just by the nature of the type of business that you have in that country. So, for example, any sort of tech firms in France are always going to be enrolled in Syntech or Sontech. They have their own website. It's great. And you then get the employment law as well as that. It varies hugely. The main thing I think with collective bargaining agreements is they are the equivalent of trade unions, but you're not dealing with the negotiation side of it. So you're going to have to abide by whatever that collective bargaining agreement says. Predominantly, they will give you additional days holiday, additional paid sickness entitlement. Some cases, it's additional pension contributions, depending on the level of employee. Once you expand and start getting a bigger headcount, that's when the Works Council side comes into it, which then does lead on to the whole termination side. So say, for instance, it's not working out with your employee in XYZ country. So first thing in Europe you're always going to need is a lot of evidence as to what you have done to try and correct this. So a PIP process does exist in Europe, but it certainly is very different in the way that it is implemented. For instance, the onus is always going to be on the employer to show that they have done absolutely everything to improve that person's performance. And the reason I focus on this is because salespeople are normally the first people who are hired into a country, and it tends to be they've either really overachieved their objectives or say they've only hit 50% and you want to part ways with them. The amount of evidence in the termination process varies hugely. I will be incredibly frank and say, in Europe, the way that most people part company will be with a settlement agreement. They used to be called compromise agreements. The US version is a release. You can, of course, terminate. But I suppose the reason I'm just laboring this is I've seen so many clients make this mistake of going, they've not worked out, we want to give them notice. So you can't necessarily in a lot of these countries just give notice. It's not the case of just writing a letter, sending it to them. Some countries it is, and then they're gone. Some countries you have to go to court to even part ways with someone. It is not an easy process. So going in, we just always want clients to go in with open eyes instead of thinking, yeah, this is great. And of course it is. It's brilliant because you're expanding, but it's the what comes next. Other great fun, and I suppose not games, but certainly in Europe, is the general data protection regulations. So most countries in Europe already had data regulations that were in place. However, GDPR essentially pulled them all together. It was an EU directive and every member state had to do it. It still applies in the UK regardless of Brexit. And this is the absolute standard of what you must adhere to. So this is ensuring that you have the consent from employees to actually keep the data that you need from them in order to pay them. And it's not a implicit consent. Everything has to be explicit consent. So you'll see forms saying like, oh, we are going to ask you to maintain this data on your age, sex, race, salary, etc., etc. It must be on file. You must check the data protection laws in each country. Every single country has their own version of the, I suppose, in the UK, it's the Information Commissioner's Office who will regulate, and if there are any breaches, they're the folks who it has to be reported into. Obviously, each country has their own version of it. One thing that does make Europe easier, at least to some extent, is the big parts of legislation like GDPR are European directives that have to be implemented into the member state law. Of course, not all countries in Europe are members of the European Union or the European Economic Area. There is a difference. I won't go into it. But just understanding that we do have lots of similarities in the countries, but we also have a huge amount of differences. Over to you, Siraj.
I think, Kim, you covered everything again very, very thoroughly on this slide. The only thing I would want to add is just one little kind of summary point, which is, again, apart from just doing your research, and this does sound very cynical, but I think as HR professionals, we have to always be thinking about these things. When it comes to hiring employees, you always have to keep in mind what will happen when they eventually separate. And so ensuring you have a very strong, compliant contract that protects the company is very important. Each country will have its own contracts and its own contract requirements. So ensure that you're working with a local counsel or local experts to draft that locally compliant contract that offers you the greatest amount of protection afforded under the law. Like I mentioned earlier, the law is very employee centric. And so your main protection is going to be not only what you actually do as an employer in terms of your day-to-day operations, but what your contract is as well, and how your contract protects you. And then also understanding the process in which employees should be separated from, meaning how you treat them during that process. And also, what are your local requirements for terminations or separations? So understanding your severance payment requirements, keeping in mind your requirements for notice periods. As an employer, you have those requirements as well. So ensuring that you are you're taking care of the employees from that perspective is also an investment in your protections when it comes to ultimately separating with their employment.
The working time regs have been in place for a number of years. Actually, they were implemented into European law, gosh, back in the late 90s. We're not going to labour over this slide. I think the one thing I will say with the European regs is this: the UK is the only one who kept its opt-out. It's fine. But what I think the main one to understand is Europe has a lot more of a right to disconnect culture. In certain countries, that is enshrined in law, that an employee can't be on call 24/7. You know, they shouldn't answer emails at 10, 11 o'clock at night. Everyone has the right to family time. So there are a number of ways that you have to track and ensure compliance. So what this essentially means is your employees are going to be doing timesheets in a number of countries to ensure that they are meeting the minimum rest periods, not the maximum working hours that they can do, but the minimum rest periods. also holiday, etc., must be tracked. So one of the things that you'll see with working time regs, and again, it's a slight deviation on this, but where holiday days must be taken because it's the use it or lose it in some countries. Do you understand the working time regs? Again, it comes from a EU directive years and years and years ago now. Gosh, it's almost 25 years. But the kind of expectation of someone being online at 7 o'clock in the morning and, you know, doing till 10 o'clock at night. Some professions obviously will require or ask that, but I would say compared to certainly how things are in the US, there is much more of a right to downtime culture, and I do say that as a Brit, and I'll let Suraj, as our resident US professional, comment on that one.
Yes, that is a great point, Kim. So the US working culture isn't necessarily compatible with the EU working culture in terms of the mandatory rest period. So like Kim mentioned earlier in the webinar, there isn't this carryover of the concept of exempt versus non-exempt employees. So even if you are having a highly comped employee who you're paying a fixed salary every month, that individual does not will one still likely be eligible for overtime. There are certain exemptions to that rule. Those exemptions are really on a case-by-case basis based on the employee seniority and their level, or not seniority, sorry, their level within the organization and what responsibilities they have. So there is a possible way to work around that up to a certain limit every week or every month, depending on that local country's legislation. But also the important piece about their right to disconnect is important. So there are some countries that have an implied right to disconnect. So that's those countries where you have to have a timesheet of when you're on the clock, essentially working for the company. That's how you're going to track your working time and determine when overtime is required to be paid. Then you have other countries like France where you have a actual legislation related to right to disconnect, which is where the employee has a right after the end of their working hours to disconnect from their email system, from their phone, and not be reachable from the employer. So it's important to understand that even though you do have an employee who, if they were in the US, would be a non-exempt employee or an exempt employee, you may still need to track their working time to ensure that you're meeting your obligations as an employer to give them their rest periods within their shift. Additionally, they're going to be rest periods within the week or within working days. So many countries are going to say that after the employee ends their work on a Monday, they can't start work on Tuesday until a certain number of hours have elapsed. So you want to keep that in mind as well.
Talking about employee benefits in Europe is very different from, I suppose, the way the US is set up. And I'm not going to speak a lot on it because it really is not my area of expertise. And if we need to, I'm sure Suraj can. Because European culture is much more, I suppose, employee-centric, socialist-centric, however you wish to say it. There are, I suppose, a lot more statutory benefits that folks are enrolled in. And I use the word folks, so clearly I am becoming Americanized. Statutory benefits in most countries are paying into the national health of that country. So that's the state provision of healthcare. So not paying into schemes like Cigna, and I don't know any other big US providers. So they're all the benefits that an employee receives from the state that they are contributing to on a monthly basis. There's a big variation on them, depends entirely on the country. Then as an employer, you don't get any option on those, you are paying into them, which then leads on to supplemental benefits. So supplemental benefits are much more along the lines of private medical, gym memberships, cars, oh gosh, all of that nice good stuff, I suppose. Even meal vouchers, which can be statutory in some places. supplemental benefits in Europe do vary hugely. As Suraj touched on earlier, having a global policy on benefits does end up being quite difficult. Some countries, Germany and the Netherlands, actually like you need to have, or an employee has to have their own private insurance, but the obligation isn't on the employer to pay for those. It's a totally standard thing that everyone has, other than Germany where it's a half contribution, but never mind. It's the fact that the employee themselves has to do it. So other supplemental benefits, I mean, you can absolutely take what you're offering in the US and go, we want to offer this here. So whether that is dental, medical, I don't know what other good stuff, free candy on a Friday, goes back to the whole research thing. It's working out what is the best for you. Now, with supplemental benefits, I think the main one to touch on is if you set up your own entity, you are going to need generally to have a minimum headcount in that country in order to source a benefits provider. What tends to be much more common when expanding in a country is including an allowance that allows the employee themselves to purchase their own benefits. Though that comes with a note of caution, because once it's in the contract, it's going to be really hard to not pay that, even when you put your benefit scheme in place. Other parts of supplemental benefits, other than the headcount, the costs just vary. It's really not going to be this hot apples for pears thing. You are going to have to work out what works for you. We or lots of other providers would be able to give advice as to what are the country norms. What is completely normal in one country will seem bizarre to somebody outside of that country, like getting paid to travel to work. You get your mileage reimbursed in some countries. It's not even a supplemental benefit. It's something that you just have to do, which leads on to mandatory benefits. So the reason that these differ, a mandatory benefit is something that you as an employer have to have in place, but you get to choose your own provider in a number of cases. So to explain what I mean by that, I suppose a little bit better, a mandatory benefit could be pension in the UK. So in the UK, we have a workplace pension provision. It's been put in place well over the last decade. And now each company, when set up, must have a workplace pension. The government requires you to do it, but you are able to go out to a pension provider of your choosing, depending on your research, and asking them to set it up for you. Other examples of mandatory benefits are health insurance. So I know I just mentioned about in Germany, like the health insurance that people have. If an employee doesn't have something enrolled, then you would automatically enroll them in the state provision. What would you like to add on benefits, Suraj, once you've finished your mouthful of water? Apologies.
No worries, Kim. So again, I think in terms of benefits, it does come down to your research part of it. So like Kim mentioned, your stat benefits are set up generally through your payroll provider, because those are benefits that are paid via payroll tax deductions. So those, like Kim was mentioning, will vary by country, but typically they're going to include your state-run health system is your typical one. And those benefits may also include non-medical benefits as well. So you'll have different leave policies that will fall under that, like some countries have disability leave policies, which may include some level of compensation paid to the employee. You may also be having policies like maternity, paternity, and parental leave as well. So those are going to be different examples of your stat benefits that you are, as an employer in that country, just by the means of employing an individual in that country, are obligated to provide to the employees. For your supplemental benefits, those are completely up to you. Those are your choice of providing benefits above and beyond. And in terms of doing your research in this capacity, it's important to understand what is customary to provide in that country. So it is important to understand in what countries does the stat benefit, do they meet the customary requirements of what an employee may expect to receive. And then for your mandatory benefits, exactly like Kim mentioned, just to kind of reiterate here, these are benefits that the government is going to require you to put in place, but you get to choose your provider who will provide those benefits to the employees.
All right, it looks like we've reached the period where we're going to do the extended Q&A. Thank you, Kim and Suraj, for all the information you provided thus far. So diving in, the first question is, what are the top mistakes companies make regarding HR when they expand into the UK? How can they be avoided?
Top mistake that people make is thinking it's going to be exactly the same as their domestic market. And I think we've covered this in length, and by domestic, I'm referring to the States, obviously, presuming that most people listening are from there. It's the fact that in the UK, a contract has to be issued on day one. So you also have to have, and I know Suraj touched on this, grievance policy, a disciplinary policy, they have to be in place. It's not negotiable. It's like a mandatory policy that, again, is almost set by statute. How to avoid mistakes? Realize and approach that each country that you go into is a very different country, and each entity is going to be very different. So again, this does come back to the research side. Avoiding mistakes, plan. What tends to happen is when clients first expand into a market, they rely too heavily on the person who they've identified to hire as to what are the norms and what should be expected there. So I think a common one actually in the UK, so the statutory holiday here is 5.6 weeks. And to explain that better, it's 20 days plus 8 days public holiday. So here you can either put your holiday entitlement to be paid, most companies mandate it. If you don't know the country, what will happen is an employee who you're hiring could go, well, everyone gets 25 days. Well, they do here. Like it's fairly standard, a 25-day holiday allowance. But you can avoid those sorts of mistakes by doing that research first. Anything to add on that one, Suraj?
I think UK is right in your wheelhouse, Kim. So I think you covered that one perfectly.
Why, thank you.
All right. So moving on to the next question. Are there any specific HR requirements for remote workers in Europe?
Yes, and again, depends entirely on the country. So and I suppose this trend obviously happened a lot quicker over the restrictions that came in place throughout the pandemic, which is still ongoing and is leading to different types of working. A lot of remote workers in Europe, if you're designating their home as their place of work, then one, their contract must be issued with their home as their place of work. So you wouldn't be able to have it as, you will work out of a random address that doesn't necessarily exist. So if you are having someone who is based at home, sorry, then different countries, when they changed their legislation for COVID, and some of this existed before. So one, you may end up compensate your employee for using their home as your place of work for them. And that can be monetary. You could be paying towards their house insurance for the change of use, I suppose, into making it business. They would also have potentially home office agreements. So as you can see, I'm working from home, Suraj is working from home. But that comes with other liabilities because, for instance, the way I'm sat, like I'm at work. If I was in an office, there would be a specific chair. You may well have a facilities department who would come around and do a desk assessment and go, are you looking at your laptop or sitting the correct way in order to do it? Now, just because someone is working from home, those, I suppose, entitlements, but also compliance still exists on your side, because it may well be that an employee could ask for a desk assessment at home, and then you would be looking into a occupational health provision or a health and safety provider to go and check their workspace. Other parts, you could be paying towards someone electric, someone's heating, whether that's an allowance, whether that is mandated. You will see in some contracts, and Spanish contracts have been interesting with this because they push legislation through quite quickly. So you have to stipulate the percentage of the employee's house that they are using for work. And you're including different allowances because they are using their domestic electric supply for private or, I suppose, business use. So again, this one really does come back to, it depends on the country, and it's ensuring that they may not be based in your office, but whilst they are working for you, what they do like at their desk is your responsibility. So if they need a light turning on, then you might be buying that light for them. It's more about having a reasonable policy on this, of course. It's not to go out and go, yes, an employee can buy whatever desk, chair they want. You still do it within the parameters of whatever your expenses were. But it's a consideration to bear in mind. Having an office would be expensive, and setting someone up to work from home, yes, it will be cheaper, but it's still not going to be cost-free. You're not just paying someone a salary and that's the end of that entitlement.
And I think just adding on, like Kim was mentioning, other countries are going to have more specific regulations. So your general policy should be one that you are treating your employees who work from home as similarly as you are treating your employees who work in an office. So if your employees in the office or employees are getting like a work phone as an example, then you would have a similar reimbursement or allowance policy for your work from home employees, because even though they are working remotely, the work that they're doing is similar or the same as those who are working in your office. Especially for those companies who are switching to a hybrid model now due to health concerns, you do want to keep in mind that your hybrid model cannot disadvantage other employees who work in one location or another. I think the other thing to keep in mind as well is in countries where there are specific legislations or requirements. So like Kim was mentioning, Spain has a work from home allowance that the government has mentioned is a requirement to provide to employees who work from home. Also, you may have health and safety requirements. Countries like Romania, where you have to have a health and safety provider actually go to the employee's house, or you're going to have the requirement to have a video teleconference appointment where a provider actually gives the employee training in home office ergonomics. That's another thing that may seem out of sorts to us who are stateside, but it is a requirement in these countries to have these. So I would say overarching theme though, just make sure that you're treating all of your employees equally. And then in those countries where you do have those specific requirements, be aware of them and make sure that you're doing your due diligence to put those in place before the employee starts. A lot of times those requirements are going to be from date of hire. So if you don't have that health and safety training before the employee starts, then you wouldn't be in compliance in those situations.
Thank you, Kim and Suraj, for the insight there. Back to the topic of benefits, what are the current benefits trends and what EU countries require the largest investment in employee benefits?
Biggest trend that is most certainly going upwards, I suppose, on benefits, lots more mental health provision or employee assistance programs, whether they are bolt-ons to schemes that are already in place, or companies who are actually setting up, who provide, I suppose, counseling, meditation tips, all of that kind of thing. They aren't that expensive benefits to put in place if they aren't there. And I think with the pandemic, and I'm just going to perhaps focus on the last couple of years, private medical has become a lot more important because, as I suppose in Europe, because it is a social state on the health service, that has become overwhelmed at times with COVID. So employers have moved to putting private medical in place. One word of caution on that is, in a lot of countries, private medical will put you back into the state system at a certain level. So it's not the case of if something terrible was to happen, you would go to a fantastic, amazing, hotel type hospital, as it were, which is kind of how it's private medical is perceived here. A lot of times it does divert back into the state health service. What other trends? Oh, hybrid working is a benefit, but isn't a benefit. I think it's where people have been at home having to look after their families. Is it a benefit to have hybrid working? Yeah, absolutely. I think if someone has been working from home and they were asked to go to the office, or they're trying to juggle, children having to go back to school, or parents or whoever going through isolation, I think everyone has had to become a lot more flexible. I know certainly it was the trend before it was enforced by the pandemic, but now it is almost expected. The idea that why would you accept a job that's an hour and a half's commute away? It's very much an employee's market on that. Biggest investment, or the largest investment in employee benefits, that really depends on the ethos of a company. So your statutory costs of benefits are going to vary widely depending on the country. So for instance, you could have like in the UK, where you've got employers' national insurance and employer pension contribution, and that's it. It's fairly cheap. So it's like what, 16.8%. And then you could go through to somewhere like Italy, where your combined social security costs, like to have someone, are going to be double that for exactly the same role. And it's just the nature of the country. It's what you're having to pay into. So I know they're not supplemental benefits, but those costs are important. You can make benefits as cheap or efficient, I suppose, or as expensive as you want. It's an employee's market, and people are looking for all the policies that will help them and their families. And I suppose that also touches on life insurance, because life insurance, especially with the COVID situation, gosh, this has got very depressing now, hasn't it? Has become very important. If a breadwinner in a family is to pass away, then I suppose the trend before, like 1 time salary, I've seen up to 5 times salary being offered now for death in service, life insurance, however you wish to refer to it. Want to add anything on that one, Suraj?
I think just the overarching theme that we're seeing is a decrease in benefits that are related to travel. So maybe reallocating funds that you allocate to annual travel, whether that be airline travel, whether that be car allowances. A lot of people are doing a lot of their meetings remotely, or telemeetings right now. So we've seen clients reallocating funds from that part of their budget into medical and life insurance, exactly like Kim was mentioning. And then those mental health based benefits, so EAP programs, maybe finding insurance policies that include mental health care as part of one of their core offerings, apart from just medical, dental, vision, but also therapy services, mental health services is another important aspect that I would expect to see moving forward as an important kind of pillar of your overarching benefits ethos.
Mm-hmm. Great. Moving forward, I think, Suraj, I'll address this question to you. So how do onboarding and offboarding requirements in Europe differ from the US?
So they do differ in a lot of different ways. So you'll have your general comparability. So, determining right to work and collecting your onboarding documents. So those are going to be your documents that payroll needs to set up an employee in payroll to get paid. So bank details, personal details, tax forms, all of that's generally the same. Now the documents will differ, but the process is generally the same. Where you have the biggest difference is timelines to get employees onboarded. So in a lot of countries, particularly those that have a socialized healthcare system, you do have to register employees with the social office in these countries. Those registration timelines will vary wildly depending on the country. As an example, countries like the UK tend to be pretty fast. You can give the government office 24, 48 hours at the most at like peak holiday times, but generally you're talking about 24 hours before an employee start date. You have to register them with the social office. What I mean by register with the social office is you are linking the employee's tax ID with your corporate tax ID, and that's good. So that way the government knows when you're deducting taxes from their payroll and you're depositing taxes to the government for your payroll taxes, who to allocate those tax contributions for. So those registrations sometimes take longer. In countries like Spain, you're looking at 3 to 5 working days. Italy, you're looking at, again, 5 or so working days. Poland, you're looking at, 8 working days. And that's because you have additional steps that you may have to do before you even do the registration. So those are referred to as our pre-hire requirements. Pre-hire requirements in many countries, or I don't want to say many, but in a handful of countries in Europe, you're going to be looking at pre-hire medical examinations, so fitness to work examinations. Those become mandatory in certain countries. I'll use Poland as an example there, where an employee has to actually go to a clinic, see a doctor, and get signed off that they are fit to work. And that's important because if you don't have those tests done, if you don't know those tests exist, those employees are not working and they're not compliant with the local employment and legislation. So that's an important consideration for onboarding. For offboarding, it's essentially that process in reverse. So you do have your normal offboarding procedure. So termination documents need to be signed. The payment of the payment terms may differ. So in some countries, you may have to pay the employee within a certain number of days after their final working date, and that may not align with your payroll process. So you may need to have a consideration around that, about processing off-cycle payrolls to ensure that you're in compliance there. Additionally, you're going to have to deregister employees after their final working date. What this means for you practically as an employer is if you do not have all of your boxes checked and you deregister an employee, it is very hard to re-register them to make any corrections. So you have to make sure that you've completed all of your offboarding steps before you deregister the employee for Social Security, because re-registering them is essentially rehiring the employee from the beginning. So that's I think the main consideration. It's not as simple as activating or deactivating in a payroll system and the system will take care of itself. It is really submitting applications to government offices so that they have visibility into what you as an employer are doing in that country.
Great. Kim, is there anything you wanted to add there?
Gosh, no, absolutely beautiful.
What is the best way to keep up with ever-changing employment laws in Europe? Are there sources that cover all countries? And are there any major changes on the horizon for 2022?
Best way to keep up with all ever-changing employment laws is to, in the nicest way, sign up for someone, either a law firm or different provision who have a network who send out updates on this. Employment law, you will get changes every month for different countries. The blunt answer is are there any sources that cover all countries? Yes and no. There are providers who say that they will, cover those updates, etc. But you may find out after the case, so you're always working retrospectively. Any major changes on the horizon? Very difficult because they are all different countries. So I am not aware that there are any pending big European economic or like EU directives that need to be implemented. But the answer is it can change quite quickly, and certainly the legislation that was pushed through quite quickly in regards to the pandemic. So countries who have previously never offered furlough entitlements pushed that through literally in the matter of a couple of months, which in the scope of law is quick. I think, as Suraj and I were saying on the webinar, it comes down to doing as much research as possible.
Great. Next up, if we were to hire a U.S. citizen living in Europe, will they be subject to U.S. or Europe HR laws?
They will be subject to the laws of the country in which they are employed. So if you have a US national who is, for example, working in France, then they are most likely going to be on a French employment contract. So it is the law of the country in which they are working that would be applicable. I caveat that with the fact it may be on secondment, but once someone is in a country for more than 6 months, that kind of is the cutoff that we use. They need to be on a localized contract and paying the correct tax and the social security. If it goes on for much longer, then you could get in serious trouble because they need to be localized.
Thank you for the insight there, Kim. The next question is, what should we consider when hiring a candidate that has a visa or other citizenship?
Most important thing to consider is what sort of tracking systems do you have in place? If it's a employer-sponsored visa, then you must have, and the word that's normally used in law on this is robust. You must have robust tracking procedures that show that you are looking at that visa and ensuring that you stay in compliance. The other part is most visas in Europe tend to be issued either on a 1 year, 3 year, or 5 year basis. Again, there are country variations on that. So it's really ensuring that that employee has the right to work. Also, bear in mind that all of the documents that they provide are going to be in the language of that country. So you may well be incurring costs quite quickly to ensure that you have the translation to fully understand what that means. Suraj, you love visas and immigration. Do you have anything you'd like to offer on that one?
Yeah, there are a couple of considerations here. So the first and foremost thing is, again, understanding what the requirements are. So in many cases, you may have employer-specific requirements when you go out to try to hire a foreign worker. So in a handful of European countries, you will need to make sure that your local entity is registered and is approved by the immigration authorities to hire and sponsor foreign workers. That's going to be kind of your first thing to kind of check off of your list here. Additionally, like Kim was mentioning, there are a lot of different visa types in Europe as well, and they vary based off of where the employee is relocating from, or what nationality they are, and what skills and qualifications they have as well. So depending on those additional factors, which from my perspective, it's always important to do a visa assessment before you go down this route. With those factors in consideration, you may have varying costs and timelines to get visas in place. It's not as simple for non-European nationals to work in Europe. There are a number of steps that must be taken in the home country before that individual can relocate to Europe. So you could be looking at a timeline that is as short as 4 weeks, but that would be extremely out of the ordinary. Typically, you're going to be looking at a timeline that's 8 weeks at minimum, and in some countries, depending on where the individual is relocating from, you could be looking at steps you have to take in your existing country that could take you 3 to 4 months to complete. So your hiring timeline is a lot lengthier when you're looking to hire an individual with a visa or other citizenship. The good news is if you have an individual who is a resident and a citizen of a country in the European Economic Area, they can work in other European Economic Area countries without requiring an additional visa. And that freedom of mobility and freedom to work is a great benefit of hiring employees in Europe in particular.
Thank you for the detail there. Next, next question is kind of around COVID. So how has COVID-19 affected European HR policies and law? And then the guidelines for work in the office. And then on top of that, are there any guidelines on whether HR can track COVID-19 vaccinations?
COVID affected HR policies and law in Europe to the extent, I suppose, very similar to the US, where it was much more work from home. In a lot of cases, that was implemented very quickly, and employees not necessarily having, I suppose, the equipment and the proper setup. This kind of goes back to the health and safety that we were discussing on the webinar. So the main changes were the very quick push through of furlough pay and also home working and how that works in practice, but also linking that into the right to disconnect. And the moment your home becomes your workplace, it is obviously a lot harder to log off. The guidelines for working in an office really vary per country again. Some countries are now very much into, well, everyone's double vaccinated, so please go back into the office. Much more common at the moment has been the move to hybrid working. You still got those with responsibilities where isolation is having to be done. Guidelines in the office still generally, I suppose, exist with either hot desking, lots of sanitizing, but they are much more on a company level. Not a lot was forced through into law really on that. Tracking COVID vaccination status, quite a contentious topic, and I do understand the question. The answer on this is there is no definitive answer, which unfortunately is probably the best answer that I can give. Certain industries, there is the obligation to disclose if you are vaccinated or not. I'm coming at this, I suppose, more from the UK standpoint. As a company, you can, in theory, make it a practice that you are asking, and this again is just the UK, that employees are vaccinated. However, this does come with a very large caveat that says you must have a genuine reason for wanting that. The right to privacy is very much enshrined in European law. So you need to have a genuine reason to request, like, are your employees vaccinated? Are they not? Realistically, as an employer, painful as it can be, it is not necessarily to do with you. I suppose the anti-vax movement is all over the place. There are people who are happy to be vaccinated, those who aren't. I think before requesting that status, it would be the due diligence of that particular country to understand why you require that information and what you are going to use that information for, which does very much closely link into the GDPR that we were discussing previously.
Great. So moving on, what are the best practices for employee compensation? Are there regulations for paying individual bonuses or a cap on bonus amounts to the percentage of base salary?
Again, hard to answer for Europe in general because there are still different regulations in country. Best practices for employee compensation. I suppose the best practice is also always to ensure that you are paying people on time. All European employment contracts will stipulate the day in which you are to be paid, whether it's the last working day. Payroll in Europe is generally once a month, which is very different to the bi-weekly cycle that you have in the US. Are there any regulations for paying bonuses? Well, this comes down to contract. So contractual wording on bonuses tends to be much more along the lines of a bonus may be applicable, and keeping it as brief as that. I think one thing to mention is that the moment you start making regular payments in Europe in general, then that can be seen as part of the contract via custom and practice. So there's not necessarily a regulation that says you need to pay out a bonus. It's just always the supporting evidence. So whether it's based on company performance and individual performance, it is how you write that into a contract. And as diligent companies who are looking to expand, you would of course have done that alongside employment lawyers in each country. Caps on bonus amounts as a percentage of salary, not that I am aware of. Certainly I know it's not in the UK, it may be the case in other countries.
Thank you, Kim. Next question is, could you provide us with some information on 2P?
2P is such a broad concept that it's hard to say like information on 2P. So briefly, 2P stands for the Transfer of Undertakings Protection of Employment. This is European legislation that was enacted into the member states. What it means in practice is if a company is buying another, and this is just a very broad example, then those employees cannot be disadvantaged by the fact that their company has been sold. It also applies in the provision of, well, a service transfer. So say, for instance, one company is managing IT outsourcing, that is moved to another company. Those employees have the right to transfer to the new company. Anything where 2P is involved, you need legal advice. Even as someone who has been doing 2P for many, many years, I will still always pass information past legal to ensure there are different ways that it is done. You will start hearing lots of statements such as what are the measures, what's the ELI. The legislation does change. The UK updates were a few years ago to reduce the parameters on it. That's the kind of most brief, but I suppose broad overview I can give on 2P without knowing much more about a situation.
The next question, I think we touched on a little bit in the hiring portion, but what are some rules around placing someone on a performance improvement plan? Is there a requirement on the amount of time for a PIP?
So placing someone on a performance improvement plan, generally the structure in which it's done, where you stipulate the objectives and what the employee needs to improve upon, doesn't change. The main, I suppose, it's not really a rule, but as always, it comes down to documentation. So if you are experiencing issues with someone's performance, what tends to happen generally is the issues have been ongoing before, well, at least 6 months before HR tends to get involved. So it's only once you stop documenting it that the PIP is documented, as it were. Anything that's verbal just doesn't count. It's a trail of emails and objectives to show the correction that needs to be made. In regards to, is there a required amount of time for a PIP, though this comes down to one of those wonderful legal concepts, the rule of what is reasonable. My UK example, again, is you would, in order to do a robust procedure, it would be at least 1 month, you then convene a disciplinary, you then put them back on a PIP, you then have another disciplinary, you then put them back on a PIP. It works like that. Reasonably, you must show that you have given them ample time to improve their performance. I think the absolute minimum I would ever say would be 3 months. It really varies by country. Some cases they will expect you to have sent employees on training courses, because the onus is much more on the employer to demonstrate why that person is failing, and it's not seen as a failure on the behalf of the employee, it's seen as a failure on behalf of the company because you have not trained your employee up well enough.
Thank you for the information there. Next up is how does hiring UK employees in the EU work now due to Brexit?
It's painfully difficult is the honest answer. So after Brexit and Article 50, you basically had a period of time. So you had to be, as a UK citizen, resident in a country on that 31st of December 2020 date. Most people aren't. What that essentially means now is if you wish to hire a UK national in Europe, they need to go through the same visa process that anyone else would go through. So it's no longer the case that you can offer a Brit a job in Germany, Sweden, any of the European Economic Area countries, and they can start. You are going to be looking at a timeline of probably a couple of months at least, so that that individual can obtain a visa. The loss of the freedom of movement is one of the most sad things about Brexit.
Thank you for the information there, Pam. Our next question is, can you provide some information on the new 30% ruling in the Netherlands?
30% ruling in the Netherlands has been established for a number of years. So what this is employees who are moving to the Netherlands to take up a job there. The most recent change was to reduce it from 10 years down to 5. So anyone who now applies for a 30% ruling would only receive that benefit for 5 years. The crux of the matter is that person must have been hired from outside of the Netherlands, or via a transfer. You can't necessarily move to the Netherlands, apply for a job, and go, I'd like to apply for the 30% ruling now. It's a great benefit for those working in the Netherlands. The taxation can be seen as quite high. Again, it depends on your basis of comparison. But that is the main change. It's to reduce the time frame that it is applicable for. It used to be for 10 years.
Next up is, what are the German personnel privacy laws? What can't we maintain in our HRIS?
So the German laws obviously come off the back of GDPR. So this is the fact that your employees, and I'm just speaking to employees, this does apply for any data that you maintain or process, they must give explicit consent for what is being maintained and processed for them. So what can't you maintain in your HRIS? It depends what you're asking and why, why you want that information on file. So If you need someone's name, their address to process payroll, great. Do you need to know that person's maiden name? Do you need to know their marital status? It's all on the basis of what information do you legitimately need to hold in order to maintain that. I suppose it's also with encryption. So under GDPR, if you are going to be processing data outside of the European Economic Area, you must also have that explicit consent. So I guess the answer is you can maintain whatever information you need. It's on you as an employer to justify why you need to hold it with that explicit consent of an employee.
Next up is, does each employment contract, if each employment contract needs to be in its own language, does this mean that, for example, in the Netherlands, the contract should be in Dutch?
So to answer the Dutch one here specifically, a Dutch contract can be in English. As long as both parties understand English and sign that document, it is legally binding. There is no need to have that issued in Dutch. It doesn't apply for other countries across Europe. You will see a lot more common that the contract will be issued in the local language, with the English being provided as a side translation. Best practice would always be to have it in the employee's like the language of employment, because it avoids any ambiguity. Understandably, as HR professionals, you're not going to know every European language. I ideally wish I did. But I suppose in the event of any dispute, what you don't ever want to have to happen is someone go, well, I signed the contract in English and it wasn't presented to me in Dutch and I don't actually understand this. Not specific to the Netherlands, but I have had that happen before, where all documents were issued in English, it was legally acceptable, and then it's a case of an employee going, but I don't understand. So I would always advise having it as a dual language contract wherever possible.
Thank you, Kim. Next up is, what circumstances lead to work council involvement in compliance requirements? Is it affected by company size in the country, certain roles, for example, exempt versus non-exempt, or other variables?
Work council tends to be involved once you reach a certain headcount or the employees request that they form one. Again, depends on the country, but generally it is much more to do with what are your headcount there. Not certain roles in particular. I think certainly the more blue collar roles, or manual, I suppose, to put it more into European vernacular, it probably would come up a bit more. The exempt, non-exempt, I know we covered in the webinar, it doesn't really exist in Europe. Like, you could have your CEO who would be entitled perhaps to overtime payments. More common is you could have a CBA but no works council.
Great. So moving forward, I think these are the last three questions. The first of which is, does working for a U.S. company in Europe come with any stigmas or specific region associated reputations?
That's a really interesting question. Can it? Yes. But I suppose what this comes down to is almost the national stereotypes of, like, the French are romantic, the Italians are verbose, the Germans are very pedantic. It's all of those kind of ridiculous stereotypes that people have in their heads. And of course, I'm not saying any of those countries or nationalities are like that. They are just the generally stated stereotypes. The world is small. Certainly, I think we all realized that even more with the pandemic, because everyone was working from home. And I think one of the best things about working internationally is meeting all of those different people. I think the biggest stigma, if I'm ever going to address one, is the expectation that people go, well, that's how it works here, so why can't we do it there? And hopefully over the course of the webinar, we've demonstrated each country is different. Like, you can have different state rules between California, Texas, Connecticut, I don't know, pick your state. It's exactly the same as it is in Europe.
Next question is kind of, again, drawing from some trends we're seeing in the US. So are we seeing the same trend in Europe that we're seeing in the US regarding the Great Resignation?
To some extent, yes. So where everyone has been working from home for a lot of time people are reassessing. It is very much an employees market in Europe. It is everyone evaluating and working out what works for them. Resignations are picking up. I absolutely noticed it amongst our clients, and I think the feedback to that is it really depends on how companies have worked with their employees throughout the pandemic. So yeah, the trend is worldwide, and it's not just limited to Europe either. We're certainly seeing it across APAC too.
Great. And then the final question, I'll just as quickly to both of you, Kim and Suraj, is what one piece of advice would you give to a company just entering European markets?
My one piece of advice, and I'll jump in and beat Suraj to this, do your research, understand what you are getting into. So don't just think, oh, this is what we want to do, we're going to do this, and this is what we do here, and it's going to work there. Research, research, research. I cannot labor it enough. Understand what that country is and what your compliance and the expectations are going to be.
Kim, you stole my piece of advice. I'm thinking something on the fly here. But what I would add on to that is, as one of the pieces of advice, is once you do your research and understand what your requirements are, please do ensure that you are trying to follow those requirements as closely as you possibly can. I know there are some things that are business decisions and there are other things that are HR decisions, but when it comes to employment law in particular, that should not be a business decision that you're choosing to follow or choosing not to. Europe is the EU in general, but European employment law, as we've mentioned in the webinar, is very employee-centric, employee-facing. So any areas where you can minimize your risk by simply following the letter of the law is highly recommended. The cost and time commitment to go back and try to fix things, or if in the event they do go wrong and you have to now deal with the consequences, can be very time consuming. But I think even more importance of that from a business perspective can be very, very expensive in terms of fines or incorrect payments that need to be made to employees, things of that nature. So not only do your research, but please ensure that you are communicating within your organization about what your requirements are and why they are so important, and that you must be following them to minimize your risk as a business.
Thank you both for your answers there. So it looks like we've reached the end of our Q&A. We want to say thank you very much for the insights to you, Kim and Suraj, and thank you to all the attendees for your questions. We appreciate everyone's participation and hope you all have a good rest of your day.